the judgment from the Supreme Court in the awaited, I would say, Menzies against Oakwood, but I'm sure that other people see it in a different way. What amounts to payment and the practical implications as a result of, although I think a lot of this talk doesn't talk about the practical implications, it talks about the background to this case, which started off, well, before we go there, I think the important point to make, and this is what happens when you're a technophobe, there you go, I've been able to get through it. Here we go. What have I done? Crimes against solicitors. And I was thinking, should this be the report of Greater Manchester Police, or should it be further down south? But that's exactly the feedback that I have gained as a result of this judgment. So I've been the junior counsel in the case since the get-go, supported and instructed by JG Solicitors. And it was only in the Supreme Court that there was a realisation, really, that we needed to get a leader on board. So Roger Mallieu, Casey came on board, and that was probably the best thing that everybody in the case would say happened, because we eventually succeeded. But the purpose of today's talk is to just look through the history of the proceedings, also the act itself, and then to consider the practical implications for claimant solicitors. So that's my mugshot there. I think it's very American in its sense, but I couldn't get anything else on Google that suited. I actually had to pay for that as well, by the way. So Section 70 of the Solicitors Act 1974, you've got a month if you're a client in order to challenge the bill that is provided. So as long as the bill is provided, there is then an option for a client to make an application for an assessment. I think everybody probably knows that. The nuance in Section 70 is subsection 2. And this is important in terms of the Supreme Court judgment as well, because what it gives after the month is the opportunity for the solicitor to make the application for assessment off their own back. And then there is the alternative subject to subsections 3 and 4 that the client will be able to ask for an assessment. And going over the page, we can see that after the expiration of 12 months, or after a judgment has been obtained, or after the bill has been paid before the expiration of 12 months from the payment of the bill, no order shall be made unless in special circumstances. So after 12 months of delivery, after a judgment has been obtained, and after the bill has been paid, and that is the start and end of this case, of the case of Oakwood and Menzies. It's about payment and what payment means. Notwithstanding that, even if payment is an issue, there needs to be special circumstances that are found. And we can see from subparagraph 4, the order to assessment conferred by subsection 2, sorry, I've gone too far in the pages, shall not be exercisable on application made by the party chargeable with the bill after the expiration of 12 months from payment of the bill. That's what this case is about. After the expiration of 12 months of payment. It's as simple as that. It's always been as simple as that, but it's not always been simple in terms of our argument going through the courts. So this all began in April 2021 when I was instructed, And we thought that once we overcome the limitation hurdle, Oakwood would say, let's settle it, let's deal with it. As a result of, we didn't quite realise the limitation hurdle that we had to overcome. There had been cases from other firms. There had been a case of myself and JG solicitors dealing with on our own, where Rowley made a judgment, and I'll go on to shortly. And we just thought that this was going to be a hurdle that we would be able to overcome again, and that ultimately settlement would follow thereafter. But again, that was April 2021, and we have an ultimate judgment in 2024. So Cost Judge Rowley was the first judge, but there was an application for a determination. It previously been at Sheffield County Court, but that was just a directions hearing. And we thought, because we had this case of Michael Potts and Amanda Cunliffe, that we would win, because what Rowley said in that case is, it may be that there was some general agreement about retaining monies on account, but it didn't evidence the specific sum claimed in the bill. And I think I've said specific sum so many times over the years after that, that I can't even hear myself say it anymore. Ultimately, that was always our case. Our case was the client has to agree to a specific sum. And this is important when we talk about the practicalities hereafter. But what Rowley said in this judgment was that what his view was, that the claimant was clear as to how much he thought his solicitors were entitled to charge him. Actually, the shortfall was less than what he thought, because what Mr. Menzies thought was that he was going to get charged 25% of damages. So it was always going to be less than a quarter of his compensation. And so the communications that followed provided the agreement that was absolutely enough for the court to say payment had occurred. What Rowley did say, which was interesting, is that he says that the final statute bill and the documentation surrounding it was some of the most impenetrable documentation that he'd seen. And that's always been an important point in our position in this case, and it's important in terms of the practicalities going forward. You need to give your clients information that is clear. There seems to be a suggestion from the courts that consumer rights are absolutely at the epitome of where we need to be at the moment. But what you need to give your clients is clarity, absolute clarity, because we are lawyers and they are not. And if a cost judge cannot interpret a bill, then how can a client? And that has to be the focus in terms of the way going forward. So to break everything down, to make it obvious in the best way that you can, because when we look at CFAs and when we look at terms of business, rather, I think even for the lawyer, it can be impenetrable, and it's important that we break it down so that it's clear. And I'm not saying break it down into a document that is only 2 pages rather than 15. What I'm saying is that it needs to be clear to the client, and that might be that your documentation is as clear as you think it can be, but it also might be that you have a conversation. And I know a lot of claimant solicitors do this, and as I said in the previous slide, I was the bad guy, because I do know that the majority of people listening to this are claimant rather than defendant. But from a claimant perspective, you need to have that conversation and make sure that they understand. It might not be the determinative factor when we're looking at assessment at a later date, but what it's important for is for your evidence, because ultimately the original case was a preliminary issue in front of Rowley, and there was witness evidence there. So that there has to be that element of, we've provided the documentation, but we've also discussed this. Now, what Rowley said was his conclusion might be the subject of an appeal. And if it was successfully appealed, the question on special circumstances would then apply. Effectively, Rowley was saying this needs to be kicked up to the higher courts, and we need a determination on this because it's been batted back and forth for so long in the lower courts, and it needs higher determination. And so it was with little push that we got permission to appeal to a high court judge, because there needed to be guidance, and ultimately there was no 19th century authority, post 19th century authority rather, on the point, and that comes into question in the later determinations and appeals, but ultimately this was a point that he thought it needed clarification. So what happened thereafter was we appealed. We got permission, as you know, because Rowley gave it to us. And then it was a matter before the Honourable Mr Justice Bourne and Cost Judge Brown as assessor. And I'm sure many defendant people would say, well, of course you got the result that you got because you had Cost Judge Brown on your side, because he is very much of the view of consumer protection. But I think the important term that came from this judgment, so the case was on the 23rd of November, the judgment was 14th of December, was that there has to be a settlement of accounts. Now, the case law that was previously referred to by Rowley supports this, and we always have said supports this issue of a settlement of account. The problem was that settlement of account was not really defined, and Bourne was the first person to make a suggestion as to what that should mean. And what he said at paragraph 36, and all these will be available in terms of the various references to the judgments and the cases therein. I've not put them on this, but they will be available once the slides are available. The only reference I've made is to the Supreme Court judgment. But the real crux of this is obtain the appellant's agreement to payment out of the actual shortfall. And that's quite important, and we'll go on to discuss that shortly. But ultimately, you can't just send somebody a bill, particularly when you've got a shortfall or an amount of success fee predicated on what the paying party pays. You can't just do that and not expect there to be no interaction with the client. And that's it. It's all, again, it refers to this issue of the specific amount referable to a bill, or whatever your determination is in terms of what you are charging the client. So it's the actual amount that's important. And then we had that, and then Oakwood appealed, and there was various factors, and I'm not going through the judgment of Mr Justice Bourne, but what I would say is that there were various factors that Oakwoods thought were unreasonable because they had been effectively added into the 1974 Act. There was this reasonable time test. There was sufficient clarity test. And he was also wrong because within his judgment, he said, well, the letter of the 11th of July 2019, and that was a letter that confirmed what Oakwoods expected the client to understand, gave the client written notice of the transfer of money. So effectively they said, here you are, we've got a CFA, we've transferred the money, and that's the end of it, but never asked for any clarification on that point. And so it was argued that that met the requirements of Section 70 of the Act. And so here we are now in the Court of Appeal, permission being granted by Lord Justice Lewison, who said there was an important point of principle here about this issue of payment by retention. And the cost judge said we needed an opinion from a higher court. So that's where we start in terms of the higher appellate courts. And then we go to the Court of Appeal on the 5th of July 2023. We have Lady Justice Simler, Lord Justice Lewison, and Sir Geoffrey Voss, Master of the Rolls. And they were the panel that petrified me more than anything at that point. The judgment, have a look at the judgment, but the one concern that I think is quite telling is that the Court of Appeal said the use of the phrase settlement of the accounts should no longer be used in this context. It's not a phrase that is used in Section 70. Its meaning is unclear. So we're looking at statutory interpretation here, and we're looking at how you consider legislation to be construed within the courts. And again, it goes on to say at paragraph 41, the phrase in the statute is payment of the bill. And then they refer to the case of Goff. Payment for the purposes of Section 70 is a transfer of money or its equivalent in satisfaction of a bill with the knowledge and consent of the payer. And I always find this an interesting comment by the Court of Appeal, because what they've said previously is we shouldn't construe settlement of account into the statute. We shouldn't build that in there, but we do have an equivalent here, which is payment for the purposes of Section 70 is transfer of money or its equivalent in satisfaction of a bill with the knowledge and consent of the payer. So again, the reference there is we don't agree with the older law, but we're going to give our own interpretation of it. And so that was a real issue in terms of our decision to appeal. But what the Court of Appeal says is what the client needs to consent to in order for payment to take place is the transfer of money, not necessarily the precise amount to be transferred. It's the process of assessment that fixes the precise amount that the client is required to pay. So this took us back from Bourne Jay's judgment to a totally different arena where effectively you don't need to be bothered about the amount that you're paying. It's the assessment that fixes the amount that the client is required to pay. And again, that troubled us because ultimately here, this is saying, well, you can charge exactly what you want as long as you've got a success fee that's in place or an agreement to take 25%. As long as it's lower than that, it doesn't matter. And then the payment is fixed in the assessment process. And for a number of reasons, we had concerns about that, because how is payment affected by an assessment process that firstly might not take place, but if it takes place, its bearing is on either whether this is a shortfall, a pure success fee against basic costs, or a shortfall against costs that are payable by the other side. So there are so many different nuances there that made it very difficult for us to accept that. And so we appealed. But ultimately, the one thing that has come out of this judgment and came out of Belsner, as you will all know about, is the fact that the 1974 Act is outdated. My view is that that's a different point to how you construe the Act, because it's currently in place and we've not had any change in legislation. But it's interesting that the Court of Appeal have concerns about the current 74 Act. And actually, that's important for claimant solicitors, because what may happen as a result of this judgment, or as a result of other movements in terms of legislation and case law, is that we really need to consider whether we need to look at the way we're charging clients, because the one thing that seems to be crucial in all these judgments, notwithstanding whether we won or we lost or whatever else, is the protection of consumers. And as claimant solicitors, but also as defendant solicitors, we have to be aware that that needs to be at the forefront of our mind. And it was very much the forefront in the Supreme Court in any event. So then what happened was we thought this was totally wrong. And then the Court of Appeal refused permission. There wasn't even any sort of context to why they refused permission. It was point blank, you've not got permission. So then what happened was I was a rabbit in headlights, because I was in this situation where I'd been on my own. Erica and Craig had been against me in the Court of Appeal, and I had no clue what I was doing, in all honesty. It was very much these are new sets of rules. I've never encountered them before, and I was absolutely a rabbit in headlights. Should we do it? Should we not do it? Caused me absolute concern, I would say, day to day. But I just thought, and JG solicitors were very much on board with the point that this was not the right decision and we needed further clarification. So at that point, we instructed a leader, and that's when things, I would say, changed for the better. We got permission. We did put forward 3 grounds, but ultimately the issue was this issue of payment and settlement of accounts, and we got permission from Lord Reed, Lord Leggett and Lord Richards to appeal to the Supreme Court on that basis. This was our panel. It was the most scary thing that I've ever done in my life, being confronted with 5 brains who were just absolutely, it was awe-inspiring. So that was our panel, and their decision, which I refer to in the next slide, you'll all be able to have access to, and I've put the decision there. But I think the press release is actually what's quite important when looking at this case. Ultimately, the conclusion of the court was that payment's not a term of art, and it's an obvious example where a bill is rendered and then paid by the client transferring money to the solicitor. So I've done your work, this is how much I charge, this is how much I pay you, you pay me. And then the response is quite, yes, here's payment. They said that obviously there can be payment by means of an authorised deduction, but it would only correspond with that previous example of payment if there was agreement as to the amount to be paid. And that's again crucial here. It's about that specific sum that takes us back to Rowley, takes us back all that way to Rowley. So that what they said was a consistent meaning as to what payment meant. And they went on to say that it was surprising if payment was to occur without there being any opportunity for the client to consider the detail of the bill of costs and to decide whether and to what extent it should be paid. And that's crucial to everybody from a claimant background. It's this ability to consider the detail of the bill and say, yes, I'm going to pay you, or no, I'm not going to pay you, and I want my right to assessment. Again, the emphasis on delivery highlights that the detail of the bill delivered and the opportunity for the client to consider that detail is of central importance. And that's as simple as this case is. Yes, we've been from the SCCO to the High Court to the Court of Appeal to the Supreme Court, but the argument has not changed at all, and it's simple. It's just the opportunity for the client to consider the detail and to say yay or nay. And again, they go on to say in the press release, considerations of ordinary meaning, context and purpose favour the client's case rather than the solicitor's. So this is simple. If you employed a builder, if you employed a plumber, you would not expect them to say, well, can you give me £20,000 on account? And then you say, absolutely, yes, I'll do that. And then the money's taken without real reference to the amount that's billable. And you never get the opportunity to say, 1 minute, I don't think that's right. And it's as simple as that. The Supreme Court went on to say that the cases since the Victorian times have said you just need to agree to the sum taken or to be taken by way of a payment of the bill of costs. It could be conduct rather than actual words, but notably there needs to be an element of acceptance. And there was a lot said by Oakwood in this regard, in the sense of how is this going to impact the solicitors? And effectively the court said, well, actually you should be doing this right anyway. So the practical implications, which is, I imagine, what people want to hear from me about rather than going through the history of the law and the case law, statutory law and the case law. You need to provide documentation that is clear. It can't be impenetrable. And this was the one thing that I've taken from Rowley's judgment, although he was against us, that to be able to expect a client to consider documentation that a cost judge, 2 barristers and solicitors on both sides to understand is just banal. So make it as clear as possible. I appreciate that it's not necessarily going to be limited because you will have very detailed documentation, but that's where it's worth having a conversation with the client, making sure they understand it. You know, this goes back to a totally separate issue of, did they understand what they were entering into, which is a totally different costs argument, but that's important and it's crucial. Once you have an offer of damages made and you are advising acceptance, because acceptance is only advised by you, send letters which says this is what the potential deduction is, and then send out forms of authority for agreement. I think an important point is the transfer of monies. Until you have got that agreement, keep the money in the account, because as soon as you transfer it, there is a suggestion there that you have already assumed that the client has accepted. Now, there are practical implications of that, because you will say, well, cash flow, everything else, we've got bills to pay and we need to deal with that. That has to be built into your business model now. There's also the issue of if you have a shortfall or you have a success fee linked to the recovery of costs inter partes, you need to go back to the client at that point as well and seek their agreement. And it might feel onerous, but again, it's going back to the example of a client who instructs a builder or instructs a plumber, and then if the costs change, they don't have that interaction. It's not difficult. You just need to send them a form of authority, but you need to do it. The client also should be informed about the potential. Now, we've had this in Bellsner, we've had it suggested in Menzies as well, about the impact in terms of being forwarded on to the Ombudsman. That should be in there, but ultimately there should be this option to go to solicitor client assessment, and it should be made as clear as possible. In my mind, it shouldn't be a footnote at the end of a letter. It should be quite clear. You have the option to do this, because you are then protecting yourselves and saying, well, they agreed to it, but also they were given the option of solicitor client assessment, and that's a possibility for them. The real concern that the majority of individuals have, if they're a claimant solicitor, is that what happens after the month and you don't hear anything? Well, you can start the assessment process yourself. And whilst I appreciate that that will be taken into account in terms of business models and the ability to necessarily go forward with these assessments because of a cost assumption, the reality of it is that you need your cases. You need to pick your cases, because if you are just taking every case to assessment, which won't happen, and in reality it won't happen, the issues where these implications are rife are either shortfall or success fee linked to costs recovered. Other than that, ultimately, think about the assessment process. Even if there's a challenge to the assessment process, the reality of it is, if your CFA is good, if your success fee is Jackson compliant, you're not going to get a reduction in terms of a solicitor client assessment. So ultimately, you need to make that risk benefit analysis in terms of whether you need to or whether it's worth the business while. But you still have that right, as much as the client had previously, or continues to, dependent on special circumstances. So this position is quite simple. There just needs to be agreement from the client to a specific sum referable to a bill of costs. As I've said, it's a lot easier in terms of success fee cases. It's more difficult for shortfall or success fee cases referable to the amount of the inter-parties assessment. And you need to make that assessment and the wider implications of the judgment on shortfalls going forward. There has been a lot in terms of commentary following this judgment that has suggested that there might be an uproar in terms of shortfalls. That's a whole other webinar, but I just highlight it for the moment. But ultimately, please don't be scared of this judgment. It's only a limitation argument. You will get a recovery as long as you play within what the court considers as reasonable. There's no element of proportionality here. It's all about reasonableness. If you work within the rules, you will be fine. Yes, you don't want to be in a situation where 6 years down the line, the client has a claim, but then you make that cost-benefit analysis as to whether you make the assessment on the risk that they will go for an assessment. But the basis of that is that they have to be successful in their assessment ultimately. And ultimately it's simple. You need to be clear and open with your clients. And you need to agree a specific sum that you intend to recoup. So whether that be shortfall, which needs a later assessment, a later agreement, whether that be success fee linked to any assessment inter partes, and then whether it be shortfall on its own. It needs to be referable to whatever those sums are. And again, it's quite simple. It's a specific sum. Client needs to know what they are going to pay. Whether that happens at stage 1, stage 2, or stage 3, it needs to be quantified and you need to get their agreement. And it's very simple. But ultimately, as I've said, it doesn't stop you from recouping an amount of money from your client. What it leads to is the potential argument that your bill is unreasonable or your incurred sums are unreasonable. And that's as far as it goes. So it's not as scary as everybody seems to be thinking it is. But what I would say is that there are potential wider implications in terms of shortfalls going forward. That's just my prediction. I might be absolutely wrong, but I think it's, as long as you are confident that you have incurred a reasonable sum and it's reasonable in amount, then you wouldn't be and shouldn't be worried by any challenges, potential challenges from your client. That's the disclaimer, because we are very early on and we haven't had the judicial response, and of course we won't at the moment in terms of how these cases are dealt with. That's just a little bit about me, and as I said to my Chambers Director earlier today, that looks nothing like me, and maybe I should have a disclaimer to say this is really me. But yeah, I think there was a lot of airbrushing involved in that picture. I could see my senior clerk nod then, which was very very supportive. I'm not going to ask for questions at the moment. You have my Chambers website address. James and Katie can be contacted as Chambers Director and Senior Clerk, and then there's the email address at costs@18sjs.com. Thank you very much for sitting in and listening to me waffle on for about something that has been 3 years of my life, which I'm very proud of, and it's been very interesting, but I'm quite glad it's over. Well, for now.